Ma'am, you need to stop resisting and get on the ground.
I'm standing still with my hands
You're being belligerent. Get down now.
Officer, I'm a sitting federal judge. You're making a serious mistake.
I don't care who you think you are. On the ground.
My hands are empty. I'm not a threat, and your camera is recording this. But understand that every second of this is being recorded, and you're violating clearly established...
Federal Judge Diane Harper was in the shopping center parking lot at 2 in the afternoon on a gray Thursday in March, loading shopping bags into the trunk of her black Mercedes-Benz. She was 63 years old, had been on the federal bench for 15 years after a distinguished career as a federal prosecutor, and wore an elegant gray wool coat over a professional dress. Diane had just left a lunch meeting with fellow attorneys and decided to take advantage of the afternoon to do some shopping before heading home. The parking lot was moderately full, with cars parked in organized rows and shoppers coming and going from the mall. It was a completely mundane and ordinary scene until it stopped being so. Diane was organizing her bags in the open trunk, moving a cardboard box to make room for a large bag containing home items she had purchased, when she noticed a police cruiser slowly approaching down the car row. She didn't think much of it initially. Security was common in mall parking lots, but then the cruiser stopped directly behind her car, blocking her in. Diane looked up confused as an officer got out of the vehicle. He was white, stocky, perhaps 40 years old, and had that aggressive authority posture Diane had seen in countless officers throughout her career, but rarely directed at her personally. The officer, whose badge said Officer D. Patterson, walked to where Diane stood and stopped just a few feet from her. He didn't say hello or excuse me for bothering you. His first question was what she was doing. Diane was momentarily speechless at the absurd question. She was obviously loading purchases into her car in a public mall parking lot. What exactly about that required explanation? She responded politely but with slight irritation that she was loading her purchases, which should be evident. Patterson didn't seem satisfied with that answer. He asked if the car was hers. Diane felt the first real pang of alarm. Where was this conversation going? Diane said yes, the car was hers, and asked if there was a problem. Patterson walked around the Mercedes looking at the plates, peering through the windows. He said he had received a report of suspicious activity involving a woman and a black Mercedes in that parking lot. Diane looked around and saw at least 5 other black Mercedes just in the immediate rows. It was one of the most common cars in that mall in an affluent neighborhood. She asked what specifically about her activity was suspicious. Patterson didn't provide a direct answer. Instead, he said he needed to see her identification and vehicle registration. Diane felt the situation beginning to slide in a direction she recognized from countless cases she had presided over on the federal bench, but never imagined experiencing personally. Diane told Patterson she would be happy to provide identification, but first would like to understand why she was being stopped, that she was a law-abiding citizen loading purchases in a Publix parking lot and deserved to know what probable cause he had to interrupt her. Patterson became visibly irritated by the question. He said he didn't have to explain his actions, that he had authority to request identification during an investigation, and that her refusal to cooperate immediately was making him more suspicious. Something was wrong. Diane almost laughed at the circularity. She was being suspicious for exercising her right to ask questions, and exercising that right was being used as evidence of criminal behavior. Diane decided she would provide identification, not because she was legally obligated to in a public parking lot without having committed a crime, but because she wanted to resolve this and go on her way. She told Patterson her purse was on the front seat of the car and she would get it. She turned toward the driver's door, but before she could open it, Patterson took a step closer and told her to stay where she was, that he would retrieve the purse. Diane turned back to face him. She said he absolutely wasn't going to search her car without a warrant or her explicit consent, and she was not consenting. Patterson said her behavior was increasingly suspicious and that if she didn't cooperate, he was going to have to take additional measures. Diane asked what measures. Was he planning to arrest her for loading purchases? Patterson called for backup over the radio, saying he had an uncooperative suspect in a black Mercedes refusing to provide identification and exhibiting erratic behavior. The way he described the situation was so distorted from reality that Diane was briefly stunned. She wasn't refusing to provide identification. She had offered to get it. She wasn't exhibiting erratic behavior. She was defending her constitutional rights. But Patterson was creating a narrative for the radio that painted him as an officer appropriately responding to a potential threat, when in reality he was harassing an innocent woman without any legitimate cause. Diane realized this was going to get worse before it got better. She pulled her cell phone from her coat pocket, preparing to record the interaction. Patterson immediately told her to put the phone away, that recording him without consent was illegal. Diane, a federal judge with decades of experience in constitutional law, calmly informed Patterson he was completely wrong, that citizens had an absolute right to record police officers performing their duties in public spaces, that this right had been repeatedly confirmed by courts, including Supreme Court decisions. Patterson didn't seem to care about legal education. He took a step closer and said if she didn't put the phone away, he would consider it a potentially dangerous object and would have to confiscate it. Diane kept the phone, now recording, and said clearly aloud for the record that it was 2:16 in the afternoon, that she was federal judge Diane Harper, that she was in a public parking lot loading purchases into her own vehicle, and that Officer Patterson was detaining her without probable cause and threatening to confiscate her phone for exercising her First Amendment rights to record police interaction. She said each word with the clarity of someone used to creating legal records. Patterson became visibly irritated when she identified herself as a federal judge. He said he didn't believe her, that people often claimed to be someone important to avoid consequences, and that she would have to prove her identity before he would accept that claim. A second patrol car arrived and a female officer got out. She was younger, perhaps 30 years old, and seemed immediately confused about why she'd been called. Patterson briefed her quickly, saying he had a suspicious woman refusing to cooperate with investigation of suspicious activity. The officer, whose badge said Officer Maria Santos, looked from Patterson to Diane, standing next to the open trunk full of shopping bags, and back to Patterson. She asked what suspicious activity specifically. Patterson said Diane was in a parking lot with a black Mercedes. Santos looked around at the several other black Mercedes in the parking lot and asked if there was anything else. Patterson said Diane was being defensive and refusing to provide identification. Diane intervened, addressing Santos directly. She explained she was federal judge Diane Harper, that she was simply loading purchases, that she had offered to provide identification but asked first why she was being stopped, and that Patterson had escalated the situation unnecessarily, that she was recording everything, and that this clearly constituted racial profiling and detention without cause. Santos looked uncomfortable. She asked Diane if she had any identification she could show. Diane said yes, that her purse was in the car, but that Patterson had refused to let her retrieve it and had threatened to search it himself without consent. Santos looked at Patterson with an expression that suggested she knew he had mishandled this. Santos told Diane she would escort her to the car to get the purse, that no one would search it without her permission. Diane agreed and walked to the driver's door with Santos beside her. She opened the door, grabbed her purse from the seat, and pulled out her wallet. Inside was her driver's license, multiple credit cards with her name, and most significantly, her official federal court identification with her photo. Full title is Honorable Diane Harper, United States District Court Judge, Southern District, and the federal court seal. She also had a professional business card with the federal court address and her chamber's number. Diane extended everything to Santos. The officer's expression changed dramatically when she saw the federal identification. Santos looked from the identification to Diane, then to Patterson, then back to the identification. She said in a low but urgent voice they had a problem, that the woman Patterson had detained and was treating as a criminal suspect was actually a federal judge. Patterson approached and took the identification from Santos's hands, studying it as if looking for evidence of forgery. He said anyone could make fake ID, that he still wasn't convinced. Diane, maintaining remarkable calm given the circumstances, told Patterson he was welcome to call the federal courthouse and verify her identity if he had doubts, that the number was on the business card, that her judicial assistant would be happy to confirm who she was. Santos was already on her phone, clearly calling her supervisor. Diane could hear one side of the conversation, Santos saying they had a sensitive situation, that Officer Patterson had stopped and detained someone claiming to be a federal judge, that the person had official-looking legitimate identification and that they needed immediate guidance. There was a pause while Santos listened. Then she said, "Yes, sir," multiple times and hung up. She turned to Patterson and said the captain was on his way and that they should maintain the scene but take no additional action until he arrived. Patterson protested they couldn't just let a suspect go. Santos said, emphasizing each word, that she wasn't a suspect, that she was a federal judge, and that they were already in deeply hot water. Diane remained standing there while they waited, her phone still recording, her posture dignified despite the indignity of the situation. Other shoppers had begun noticing the commotion, some stopping to watch from a distance, some pulling out phones to record as well. Diane was aware she was creating a scene in a public parking lot, but also knew documentation would be crucial. She had spent decades in the legal system. She knew exactly how officers could distort narratives when there was no objective evidence. Video from her phone and potentially from bystanders would ensure the true version of events was preserved. An unmarked SUV arrived 8 minutes later. A middle-aged man in civilian clothes, but clearly a high-ranking officer, got out and walked quickly to the group. His face was red, a combination of anger and embarrassment. He approached Diane directly and immediately began apologizing. He said he was Captain Robert Chen, that he was deeply embarrassed by what had happened, and that this was a terrible misunderstanding that would be handled appropriately. Diane interrupted him. She said it wasn't a misunderstanding. It was flagrant racial profiling followed by illegal detention, that she had been stopped without cause, interrogated without reason, and treated like a criminal for loading purchases in a public parking lot, and that the only reason she was being released now was because her identity as a federal judge had been discovered. Chen tried again to express regret, but Diane wasn't finished. She asked how many other people Patterson had stopped this way. How many other innocent citizens, particularly people of color, had been harassed in parking lots and streets without probable cause? How many didn't have a title or position that would force the department to pay attention? Chen had no good answer. He said this would be fully investigated. Diane said she hoped it would be, because she would be filing a formal complaint, and that her video and any video from bystanders would be shared with media and civil rights organizations. That this wasn't just going to disappear because she was a judge. In fact, her position gave her a platform to ensure it received the attention it deserved. Patterson finally spoke, trying to defend himself. He said he was just responding to a call about suspicious activity, that he had followed protocol, that he couldn't have known she was a judge. Diane turned to face him directly. She said the entire point was it shouldn't matter who she was, that every citizen deserved to be treated with dignity and respect, not just those with impressive titles, that he had no probable cause to stop her, no legal justification to detain her, and no excuse to escalate the situation the way he did, that if he treated all suspects this way, then he was a danger to the community. And if he only treated certain types of suspects this way, well, then everyone knew exactly what the problem was. Chen told Diane she was free to go, that he deeply regretted the inconvenience, and that the department would be in touch. Diane said it wasn't an inconvenience, it was a violation of her constitutional rights, that she wasn't just going to drive away and pretend nothing had happened. She asked Chen what the original suspicious activity call had been. Chen hesitated, then admitted he would have to check the dispatch records. Diane said she wanted a copy of those records, wanted to know exactly who called and what they said. Chen said there might be privacy issues. Diane reminded him she was a federal judge familiar with public records law and that she was making a formal request. Diane finally closed the trunk of her Mercedes, got in the car, and drove home. Her hands trembled slightly on the steering wheel, adrenaline and anger finally breaking through the professional calm she had maintained throughout the entire interaction. She had been a judge for 15 years, a federal prosecutor before that, had graduated from Yale Law School, had dedicated her entire life to the legal system. And yet, in a mall parking lot in broad daylight, she had been treated like a criminal simply for existing while black in a luxury car. The humiliation was deep, but the anger was deeper. Because she knew that if she weren't a federal judge, if she were just Diane Harper, ordinary citizen, the situation could have ended very differently. At home, Diane immediately began documenting everything. She transferred the video from her phone to her computer, making multiple backup copies. She wrote a detailed account of the interaction while it was fresh in her memory, including every word exchanged she could remember, physical descriptions of the officers, badge numbers, exact time and location. Then she called a longtime friend and colleague, Federal Judge Cassandra Williams, who had experienced similar discrimination years before. Cassandra listened to the entire story and then said something Diane already knew but needed to hear. She said Diane had a platform and responsibility to turn this into real change, that staying quiet would protect the department, but would fail countless others who would face similar treatment without resources to fight back. Diane contacted a civil rights attorney named Thomas Rodriguez, who had successfully litigated multiple cases against police departments for racial misconduct. Thomas reviewed Diane's video and said it was one of the clearest examples of racial profiling and detention without cause he had ever seen. Her identification as a federal judge actually made it worse in some ways, because it demonstrated that even people in the highest positions of authority and respect weren't immune when the color of their skin was the deciding factor. Thomas recommended a federal lawsuit under Section 1983 for civil rights violations, and also a state lawsuit for false imprisonment, intentional infliction of emotional distress, and invasion of privacy. He said they should seek not just damages but also injunctive relief, requiring comprehensive policy changes. The story leaked to media within 3 days. One of the bystanders who had recorded video in the parking lot posted it on social media with a caption identifying the woman being harassed as a federal judge. The video went viral immediately. People were shocked that a respected federal judge could be treated this way. Civil rights organizations issued statements expressing outrage. Elected officials were forced to comment. The police department issued a statement saying they took allegations seriously and that a full investigation was underway. But the statement was met with skepticism, especially when it came to light that Patterson had a history of similar complaints. Investigative reporters began digging into Patterson's history. They discovered that in his 6 years with the department, he had generated a disproportionately high number of citizen complaints, 12 in total, with 8 involving allegations of discriminatory treatment against people of color. None had resulted in serious discipline beyond verbal warnings and mandatory training that clearly hadn't changed his behavior. One particularly disturbing case involved a black man Patterson had stopped for allegedly matching a suspect description, but the description was so vague, black man in his 30s, average height, wearing casual clothes, that it could have applied to thousands of people. The man had been detained for 40 minutes before being released without charges. The internal affairs investigation moved faster than usual, clearly driven by the fact the victim was a federal judge, and media coverage was intense. Investigators interviewed Patterson, Santos, Chen, and multiple witnesses from the parking lot. They reviewed dispatch records for the original suspicious activity call. What they found was revealing. The call had come from an anonymous woman who reported seeing a black woman acting suspicious around luxury cars in the parking lot. When the dispatcher asked what specifically was suspicious about the behavior, the caller said the woman didn't look like she belonged in that type of car. The entire call was based on nothing but the caller's racial prejudice, and Patterson had responded to it without questioning whether there was any actual crime being committed. The internal affairs investigation findings were issued 5 weeks after the incident. Patterson was found guilty of multiple violations, including detention without reasonable probable cause, failure to articulate specific criminal suspicion, unnecessary escalation of civilian encounter, and demonstration of a pattern of discriminatory behavior. The recommendation was termination. Santos received a written reprimand for not intervening more assertively when it became clear the stop had no merit. Chen received a 2-week suspension without pay for failure to adequately supervise officers under his command and not addressing Patterson's established pattern of complaints. The police chief accepted all recommendations. Patterson was fired, effective immediately, his law enforcement certification suspended pending state review. Patterson tried to contest the termination through the police union. His lawyer argued he had followed protocol in responding to a dispatch call, that he couldn't have known the caller was operating under racial prejudice, and that he had treated Diane the same way he would treat anyone else in similar circumstances. But the arbitrator who reviewed the case wasn't persuaded. The decision pointed out Patterson had responded to an incredibly vague description without making any attempt to determine if an actual crime was being committed, that he had escalated the situation at every turn instead of de-escalating, that his pattern of complaints demonstrated consistent bias, and that his actions had violated not just departmental policy but fundamental constitutional rights. The termination was upheld. Thomas Rodriguez filed the federal lawsuit 6 months after the incident. The lawsuit named Patterson personally, as well as the police department and the city. The allegations were extensive and detailed, based not just on Diane's experience, but on Patterson's documented pattern of misconduct. The amount sought was $1,200,000 in compensatory and punitive damages. But more important than money were the reforms demanded. The lawsuit demanded implementation of a comprehensive tracking system to identify officers with patterns of racial complaints. Revised mandatory training on racial profiling that was substantial and not just a box-checking exercise. Creation of a civilian oversight panel with real power to review cases and recommend discipline. And clear policies about when officers could legally detain someone on public property. The city tried to settle quickly. The city's lawyers knew they had a loser. The victim was a respected federal judge. Video evidence was undeniable. Patterson's pattern of misconduct was well documented, and media coverage had been devastating to the department's reputation. The initial offer was $400,000. Thomas rejected it immediately as inadequate given the severity of the violations and the pattern of systemic failure that had allowed Patterson to operate unchecked for years. Negotiations continued. The city increased to $600,000. Thomas counteroffered $850,000. Eventually, they settled at $675,000, with all money coming from the city and department insurer since Patterson was bankrupt. The settlement also included every one of the policy reforms Thomas had demanded. Diane used her portion of the settlement to establish a foundation dedicated to providing legal assistance for victims of racial profiling by law enforcement. The Harper Justice Foundation, as it was named, offered free legal representation, helped people document police encounters, and worked with police reform advocates. In its first year, the foundation helped 32 people file complaints or lawsuits against officers for discriminatory treatment. Diane also donated $100,000 to civil rights organizations working on criminal justice reform, and established a scholarship program for students of color interested in careers in law with a focus on civil rights. Diane's case received significant attention not just locally, but nationally. She was invited to speak at legal conferences, appeared on news programs, and wrote an op-ed for a national newspaper about her experience. On each platform, she emphasized the same points, that she had been fortunate to have resources, knowledge, and position to fight back, that countless others faced similar treatment every day without those advantages, that the problem wasn't just individual bad officers, but systems that allowed bad officers to operate without accountability, and that real change required not just punishing individual misconduct, but reforming the policies, training, and culture that allowed that misconduct to flourish. Patterson disappeared from public life after his termination. He tried to find work in private security, but discovered the viral video and media coverage followed him wherever he went. Employers who searched his name online immediately found the story of how he had harassed a federal judge in a parking lot, the multiple previous complaints against him, and the detailed analysis of his pattern of discriminatory behavior. He ended up moving to another state, reportedly working in a job unrelated to law enforcement under much reduced circumstances. Some acquaintances expressed sympathy, saying one error in judgment had cost his career. But others pointed out it wasn't one error, it was the culmination of 6 years of documented misconduct that finally found a victim with resources to hold him accountable. The reforms implemented as part of the settlement began having measurable impact. The new tracking system identified 3 other officers with similar patterns of disproportionate complaints from communities of color. 2 were placed in intensive training and close monitoring. The 3rd was fired after investigation revealed multiple policy violations. The revised racial bias training went from 2 hours online to a 40-hour program distributed throughout the year, including scenario exercises, guest speakers from affected communities, and actual competency assessments instead of just attendance checking. and the Civilian Oversight Panel, composed of community residents from diverse backgrounds, began reviewing all racial discrimination complaints with power to recommend discipline that the police chief had to seriously consider or publicly explain why he was rejecting. Diane returned to the federal bench where she continued presiding over cases with the same distinction she had demonstrated for 15 years. But her experience had changed her in ways she hadn't anticipated. She became more attentive to racial profiling issues in cases that came before her. When prosecutors presented cases based on traffic stops or pedestrian detentions, she scrutinized probable cause more closely, asking pointed questions about why the officer had chosen to stop that specific individual. When defense attorneys raised issues about discriminatory treatment by law enforcement, she listened with new appreciation for how even people with nothing to hide could be made to feel criminal simply by exercising their rights. Several years after the incident, Diane was invited to give the keynote address at a new department initiative on community police relations. She accepted, but made clear she wasn't going to give the department easy approval. In her speech, she described her experience in the parking lot in vivid detail. She described the fear she felt when Patterson invaded her personal space, the humiliation of being treated like a criminal in front of other shoppers, the anger of knowing her skin color had been the only factor that made her suspicious in his eyes. She also described her determination to use her position and resources to create change, not just for herself, but for all those who would come after. The parking lot where it all happened had no physical marker or plaque, but it became locally known as the place where a federal judge was profiled. Residents occasionally referenced it when discussing discrimination and police reform. Some saw it as a reminder that no one was immune to prejudice, not even those in the highest positions of authority. Others saw it as an example of why documentation through video was crucial, why speaking up mattered, and why people with platforms had a responsibility to use those platforms for change. The 3-minute video recorded on Diane's phone, along with videos from multiple witnesses, had preserved truth in a way that couldn't be denied or revised. The case Diane Harper versus City became widely cited in police academy courses as an example of what not to do. Instructors used the video to demonstrate how unexamined biases could lead even experienced officers to make terrible decisions. They showed how unnecessary escalation transformed an innocuous civilian encounter into a crisis that cost an officer his career and the city hundreds of thousands of dollars. And they emphasized that in an era of ubiquitous cell phone cameras, every police interaction was potentially being documented, so professionalism and respect for constitutional rights weren't just moral imperatives, but practical necessities. Law schools used the case in courses on civil rights and Section 1983 litigation. Professors discussed how Diane's position as a federal judge had simultaneously made the case more publicly shocking, but also highlighted disparities in how people with different levels of resources and knowledge could respond to discriminatory treatment. They asked students whether justice was truly served when only those with impressive titles and deep pockets could obtain full accountability for rights violations. The case sparked discussions about access to justice, about the need for free legal assistance for victims of police misconduct, and about how systems could be reformed to protect everyone equally. Patterson never publicly apologized to Diane. He never acknowledged his actions had been based on racial prejudice. In a rare interview years later, he maintained he had simply been doing his job, responding to a dispatch call, following his best judgment at the moment. He said he regretted how things had escalated but didn't see how he could have done differently. That lack of self-reflection, that inability or refusal to acknowledge his own biases, was exactly why systemic reform was necessary. Officers like Patterson operated under unconscious assumptions about who looked suspicious, about who belonged in luxury cars or affluent neighborhoods, and those assumptions led to real harm for real people. For Diane, the incident never became just a story she told at speeches. It remained a lived experience that informed her daily. Each time she entered a parking lot, there was a moment of hesitation, a memory of how quickly a normal situation could become a confrontation. Each time she saw a police cruiser, she felt a pang of something that wasn't present before that March afternoon. But she had transformed that traumatic experience into purpose. The Harper Justice Foundation had helped hundreds of people. The scholarship program she established had sent dozens of students of color to law school. And the policy reforms her case forced had made at least one city a bit more accountable. The $675,000 settlement represented much more than monetary compensation. It was acknowledgement that Diane's rights had been violated, that she had been harmed, and that there was a price for that harm. It was a message to the police department that allowing officers with patterns of discrimination to operate without accountability was expensive in legal and financial terms beyond the human costs. And it was validation for countless other people who had experienced similar treatment but wondered if they were just being sensitive, if it really had been that bad, if anyone would believe them. The video proved yes, it had been that bad. That racial bias in law enforcement was real. And that accountability was possible. Years after the incident, when interviewers asked Diane how she felt about everything, she always gave a carefully considered answer. She said she wished it had never happened, that no one should have to experience the humiliation of being profiled. But since it did happen, she was satisfied there was accountability, that changes were forced, and that her experience could serve as a tool to educate and reform. That the $675,000 wasn't about enriching her, but about putting a price on violation of dignity and rights that was high enough to make cities and departments think twice. And that her hope was eventually no one would have to be a federal judge to be treated with basic respect by those who swore to serve and protect. Patterson's career as a police officer lasted 6 years. In that time, he had generated 12 citizen complaints, 8 alleging racial discrimination. None had resulted in more than verbal warning until he chose the wrong target in a mall parking lot. The judge he thought he could intimidate turned out to be the person who exposed years of misconduct and forced reforms that would protect countless others. 3 minutes of video captured on cell phones changed everything. And the woman who was simply loading purchases into her car transformed a moment of injustice into a catalyst for change, proving that even when systems fail, determined individuals with resources and platforms could demand better and sometimes actually get it.